Now in this video, I will be presenting my research and thoughts on the maxims equity will not perfect an imperfect gift, and the maxim equity will not assist a volunteer, and how these maxims contradict the settler's intentions. Alright, so before we dive in, my name is Kazim, Muhammad Kazim, and I hope by the end of this presentation, you all, whoever you are that's watching, will have benefited from my research with a clearer view on this specific subject matter. Right? Now, let's begin with the maxims itself. Equity will not perfect an imperfect gift, and equity will not assist a volunteer. They are fundamental principles in the realm of equity and trust in the UK, and they play a crucial role in determining the enforceability and validity of gifts and voluntary transactions. Now, to critically analyze whether these maxims contradict a settler's intentions, we need to understand their meanings and the implications that come with it. Now, with that being said, let's waste no time and let us dive into the main aim of the whole process stipulated, which is to ensure that a trust is constituted. That is what all this is about, to ensure a trust is constituted. Now, according to an article by John Hopkins, the need for a trust to be constituted is when a voluntary disposition of a property is made with the necessary formalities to be complied. Now, in simpler terms, this explains that in setting up a trust, the settler must complete all the proper steps and procedures for it to be valid. Now, this principle or this idea itself was based on a landmark case in equity and trust by the name of Milroy and Lord, 1862. The case plays a crucial role in making our discussion clearer. And the facts of the case are as follows, and I do note that I will be going through them very, very briefly. Right? Now, the facts of the case goes like this. The settler in the case intended to set up a trust for his niece, which is gifting the niece something, his estate. However, doing that, he followed incorrect formalities. And since incorrect formalities were done, unfortunately, subsequently, the settler died. Now, since that is what happened in the case, now following the understandings of common law for equity and trust, the niece, who we clearly understood in the case did not provide any consideration for the gift in return, is now considered a volunteer. The trust itself, since incorrect formalities are done and are not followed, the proper ones, the trust is considered to be not constituted, and therefore birth the concept of an imperfect gift. That is what the imperfect gift refers to in the maxims. Now, moving forward, the case also laid out 3 modes to make a voluntary disposition. Only 3 modes. Now, as per Lord Justice Turner expressed in the case, first one is for it to be an outright gift. Second is for it to be transferred into a trust. And the third one is to declare the volunteer as a trustee. To summarize, this means that a perfect gift that is set up following all the correct formalities by one of the chosen modes. Now, Lord Justice Turner also expressed that in the event that the proper formalities in making a voluntary disposition, according to those 3 modes, if it is not followed, the courts will not budge to give effect to it, the trust, by applying a different mode. Alright? Now, Julie Kruko and 2 other authors expressed in an article that this is the legal principle that made the case itself a landmark case. The principle simply states, in a simpler term, that if the settler uses one of the 3 modes and did it wrong, the court will not help or give any face and declare it to be invalid. They will not proceed the trust through other modes, even if it is possible. Now, this principle from Milroy and Law, Mark Warwick also explained in an article that in unison, the court's decision had also removed any aid to the intended beneficiary, as when the constitution of the trust failed, the intended beneficiary is known as a volunteer in the eyes of the law, as they do not provide any consideration for the disposition in return for the gift itself. So the dissolution, no consideration, they are volunteer. Now this is where the maxims appear. In Milroy and Law 1862, it presented the principle which reflected the maxims itself. Equity will not perfect an imperfect gift. Now, as it was clear that the courts will not change to another mode of disposition when the relevant formalities is failed to be done with the intended mode. However, for the other maxim, which is the maxim equity will not assist a volunteer, it is reflected as the court's decision is not providing any aid to the volunteer. That is the consequences of the action. The action itself was the first maxim, the consequences is the second maxim. Now, according to an article by Simon Gardner, many scholars believe that these two maxims are usually used in pairs and become expressed as the maxim equity will not assist a volunteer to perfect an imperfect gift. The court's decision reflects the first maxim. The second maxim is reflected in the consequences of the court's decision. The court decided that equity will not imperfect an imperfect gift, and in doing so brought out the consequence where the volunteer in the circumstance of the case is not assisted by the law to receive their gift. Now, moving forward to another part of the video, which is a also crucial part. Now, moving away from the maxims, we pay attention to the settler's intention. Now, it may be argued by most, by the common people, that the intention of a settler is to ensure that their disposition is done. Now, the settler itself, by common sense, of course, intends to have their beneficiaries receive their gifts. The gifts that they want to give, they want those people to receive them. Right? Now, the maxims, in a way, have made it hard for this to be done. And when the necessary formalities are not complied, the maxims cause the settler's intention to be contradicted. They get in the way. When you don't follow the proper procedures, they get in the way. The maxims of equity, we must understand this, is the maxim of equity. With reference from an article by J.D. Davis, it is important to consider that equity and trust law prioritizes legal formalities and clarities in transactions to ensure certainty and prevent abuse or fraud. The courts, by this understanding, do not intend to contradict the settler's intention, rather to ensure that they are carried out swiftly and successfully. And what the courts basically is telling the settler is that if for it to be done swiftly, successfully, proper, and to be done in a proper way, basically, it requires proper preparation according and must be in accordance to legal regulations. So this is one part that we must understand, that it is not that the maxims contradict, but the maxims merely straighten the settler's intention. So if I choose to gift my estate through as an absolute gift, I must comply with all the formalities that the law sets. Follow what sections tells me to do what. What the courts require me to do, I must do it. Then only if I intend for my gift to be received by the receiver, then it will be received. And if I don't, the maxims will come in and say they won't help my receiver receive my gift. They won't help me give my gift through a different mode. They won't change to it. They won't help me to declare my gift as a trust. They won't even help my beneficiary declare themselves as a trustee. Now that we understand all that, now let's say the settler's benefits, when the settler's intentions are still contradicted. Now, for their own benefit. Every legal principle in all parts of the law has an exception. And fortunate enough, the maxims itself also have their own exceptions. First one is we look at the case of Rose, 1952, where it says that a donor has, if a donor has done everything possible to transfer legal title, but the transfer is delayed by the ordinary operations of the law, the gift is still valid. Simply put, the maxim does not apply if the necessities are done to transfer, but the transfer itself has yet to happen. The gift is valid irregardless of the circumstances. Sarah Laurie and Paul Todd explain in the article that the exemption is best explained through the case of Pennington and Wayne. But the case is a rather narrow explanation. In a simpler term, if I were to transfer something, my gift, to the beneficiary, right? The beneficiary, the receiver of my gift. And let's say my gift itself, I've done everything to transfer it. But by law, it says that the transfer will only be official by the end of the year. And if I die, the transfer will still go through thanks to this exception, because I have done everything necessary. And if in the event of my death I have not done all the necessities, but all the transferring, the necessities of transferring is done, it is done. This is what the exception explains. Alright, now moving on to another exception, which we can explore apart from Rose, is Strong and Bird, 1874. This situation is where this situation comes up, this exception itself comes up where in a situation where there is debt. The case itself has a debtor who apparently was appointed as an executor for the trust of the creditor itself. And therefore the courts decided that the debt is discharged and accepted the discharge as a voluntary dissolution. Now, in this case, the maxims does not apply. According to an article by John Mee, through this exception, the Strong and Bird exception, that this exception itself is simple, but it is not an exception that is commonly applicable because it is not a common case. This is because the case itself has unique facts where the debtor is appointed as the creditor's executor, and therefore the debt is deemed as redundant. A great highlight in the case, to make it more clearer, is that the courts implied that to regain the debt back, the debtor must sue himself, which is impossible. Now, with that being said, these exemptions are only a few of the available ones for the maxims. Alright, there are more exceptions, but these two are the ones I can currently highlight. And these exceptions should serve as a sword that the settlers can use to pierce the shield of maxims of equity. Alright? Because like maxim has a shield and this is a sword. It also shows that the maxims are absolute to a certain degree. Right? Doesn't mean that the maxim says they don't assist a volunteer. In some cases, the volunteer receive assistance, not directly, but because of the given circumstances. Right? Such as in Strong and Bird, the debtor is the executor for the creditor. The discharge of the debt is the gift, and the maxims could not stop that. It is a rare case where they need debt. Right? So the maxims are absolute only to a certain degree. Now we've reached to the end of this presentation. After a thorough analysis that we did together of the maxims, it is verified that it does not contradict, nor does it limit the settler's intention. Right? This is what we understood. No contradiction, and doesn't limit the intention. Rather, the laws of equity provides that if a settler that intends to set up a trust or make a gift, he can do so provided that careful steps and legal requirements of the law are met, as this is to allow equity itself to serve its purpose and benefit the settler's intent. Now with that, I reached the end of our discussion. Thank you so much for listening, who you are, wherever you are. My name is Kazim, and goodbye.